Good evening, this is John Milburn for LAWS12062. This is Alternative Dispute Resolution. We're into week 9. We're into the home straight now. And tonight we're going to continue our discussion in relation to other general means of resolving disputes beyond the usual mainstream methods of mediation, conciliation, arbitration, and straight out negotiation. So we'll commence tonight with the discussion of those types of ADR processes that are what I would name, what I've named as number 9, 10, and 11 when referring to the continuum on page 3 of your text. So number 9 is expert appraisal, number 10 is expert determination, and number 11 is early neutral evaluation. Now, if I was to ask anyone to describe in a minute or so the difference between those three, the differences and similarities, would you be able to do that? Would you wish to do that? Don't worry, I'm not putting the pressure on, just asking a question. So let's go through it, and if you wish to add anything to the discussion as we proceed, please let me know. So when we think about these on the continuum, we see straight away that they're towards the more formal of the approaches that might be considered. So they're the type of procedures that are more formalised and non-consensual, as opposed to the informal and consensual. And of course, we can tell from the numbering that the most informal of those three is expert appraisal, then expert determination, then early neutral evaluation. So they become progressively more formal in their nature. Let's consider some of the highlights in relation to these. Firstly, case appraisal, which is number 9 of 14. And contrast that to expert determination and early neutral evaluation. Now, of course, they're all very similar. They're all processes that generally relate more to adjudication than consensus. And confusingly, the terms are used somewhat interchangeably at times. And there's no clear uniformity in terms of the terms that are used, so that adds to the confusion. Some of these do have statutory force, and we'll talk about some of the statutes that refer to these ADR processes as we proceed through tonight. So when we look at case or expert appraisal, which is number 9, it is generally not binding, or if it's something which is court-ordered case appraisal, then it might be conditionally binding. And can anyone tell me who would normally undertake case or expert appraisal? There's a bit of a hint in the name there, isn't there? Not so much
suitably qualified expert in the field?
Yes, indeed. Thank you, Jack. Thank you, Peter. I could see you were onto that as well. So when you think about case or expert appraisal, of course, we think about who is the ADR practitioner behind this. And it's usually an industry expert. It is, certainly compared to the other two that we're talking about right now, relatively informal. What are some of the hallmarks of the informality that might apply, do you think, to case or expert appraisal? What would make it relatively informal? So Emma says we're talking about someone with skills in the area, yes. When we talk about, yes, Peter?
I think the informality would come from the fact that the process itself would probably be less formal than a court process. However, they would probably here it'd be more formal than a mediation session, for instance.
Exactly, Peter. Look, I think if you're looking for some indication as to what makes these things different to each other, then think about where it is on the continuum, on that graph that I mentioned, and think about some of the hallmarks of arbitration, for example, which is closest to court-like. So in arbitration, for example, the rules of natural justice apply. There's generally a need for a written decision, the award that's made. The decision can, in fact, sometimes be made public. So these are some of the hallmarks of the more formal approaches to ADR. So in terms of case or expert appraisal, it's relatively informal because the rules of natural justice don't apply. There's no need for a written decision, and the appraiser will simply suggest a desired outcome. The parties are free to accept it or reject it. It's not binding. So it's quite a formal process, but it's relatively informal in the way in which the process is actually conducted. Expert determination, which is the next one along the line, number 10, is again an ADR process, but this time it is binding. And who do you think undertakes the expert? Jack is right onto this now. Who undertakes the expert determination? Someone other than Jack can answer this one. Peter says the expert. Thank you very much. So it's undertaken by an industry expert. It's still relatively informal. And again, there's no general rule that it be a written decision, but it is binding. Now, early neutral evaluation, a little more formal again, is binding, but binding in relation to the extent to which the brief is delivered. By that I mean it's binding as to a finding of the key issue in dispute. And this is a little different because you'll note that the word expert is not included in the name. So who do you think undertakes an early neutral evaluation? It is an expert, but a particular type of expert. Judge, close.
Barristers?
Yes, potentially barristers. So usually lawyers. So it's an expert who is in the legal field will undertake an early neutral evaluation. And the word evaluation gives you that feeling that the person is looking at the material and coming to some evaluation of the strengths and weaknesses and what it's likely to be. So sometimes the name gives you a hint as to what it's all about. So it's usually a lawyer. It's relatively informal, even though it's a formalised type process. It's not specifically governed by legislation, but there is similarity in that there's no need for a written decision and the decision remains private. So when we look at that, it's important for you to create for yourself a list of things that describe the operation of appraisals, expert determination, evaluation, get an idea of the extent to which they may or may not be binding, and what are the differences, what are the similarities. A great way to start is look at NADRAC, always a good way to start. So by way of refresher, let's have a look at what NADRAC has to say. Firstly, case appraisal. It's a process in which the dispute resolution practitioner, the appraiser, investigates the dispute, provides advice on possible and desirable outcomes. Now that term, unfortunately, as used by NADRAC, is almost the same as early neutral evaluation. And this is where it becomes confusing. So I went back to an earlier point. Have a look at the Civil Proceedings Act 2011, which is Queensland legislation, and have a look at section 46. We'll revisit this, but I'll share the screen. No, I won't. Section 46 is part of Part 6 of the Civil Proceedings Act, and it's in Division 3, which talks about ADR process, and Section 46 is subpoenas. So a court may subpoena a person to attend a court or a case appraisal. Now, NADRAC describe expert determination as a process in which the participants present arguments and evidence to a dispute resolution practitioner who is chosen on the basis of specialist qualifications or expert in a field, and that person makes a decision or decides. And early neutral evaluation is where the person again decides, but does so in relation to a key issue and without necessarily determining the facts in dispute. All right, so try and get some idea of when it's binding, when it's not binding. If you want to look at a case, there's a decision of IPOH. IPO, I'm not sure if that's the way I pronounce it. IPOH against TPS Property, number 2, numeral 2, and another 2004 NSWSC, the New South Wales Supreme Court, 289. It's to do with an expert determination clause and arguments around breach of contract. Have a look at paragraphs 91 and 103 of that decision. So what are some of the key differences? Well, in case appraisal, the appraiser suggests a desired outcome. The parties may accept it, they may not. In an expert appraisal, the appraiser suggests a desirable outcome. And again, that's not usually binding. And in expert determination, the expert provides a determination, which is an adjudication of the dispute to some degree. Now, I mentioned earlier the Civil Proceedings Act. I will share the screen now. I'll invite you to call this up on your screen and please find your way to Part 6. So this is Queensland legislation. Part 6, you'll see in that which I've brought up on the screen relates to ADR processes. And sections 37 through to the end of the part, which is 54, deal with the way in which ADR processes are dealt with in a court context. The important sections that I want you to look at, well, all of them really, but pay particular attention to section 41 that deals with case appraisal. And when you do, you will look at it and you'll think, yeah, the definition of case appraisal in section 41 is very similar to neutral evaluation or expert determination. So there is an overlap here. Further evidence that case appraisal is effectively neutral evaluation is found in section 45. Again, I'm trying to provide you with some answers and probably not giving you a lot of encouragement or hope here, because I'm providing you with some statements, for example, from NADRAC, and then saying, yes, but if you look at the Civil Proceedings Act and some of the definitions, they muddy the waters just a little. I guess if we have to, we'd go with legislation, wouldn't we, rather than NADRAC. So have a look at section 41, have a look at section 45, have a look at section 43, and you'll see there in section 43 that a court may refer a dispute to ADR process. What that tells me is that if you're involved in civil litigation, I say civil because of the nature of the Act, this is the Civil Proceedings Act, then as a practitioner, you must always be mindful of the possibility of agitating before the court for it to refer the matter to ADR process if you believe that that's advantageous to your client. So do have a look at section 43, get a feel for what is the trigger for the court to make the referral to ADR, and you'll see that it's if a party applies for that order or the parties are otherwise before the court can make the order which is called a referring order to mediation or case appraisal. And in section 43 subsection 4, and I'll call it up, you'll see that the court has some issues that it might consider. So without limiting the court's discretion, it takes into account a number of things before making the decision. Now, when you're undertaking this work, you'll also need to consider some of the rules that work in conjunction with the legislation. This is the Civil Proceedings Act Queensland. Can anyone tell me what is the likely set of rules that relate to this piece of legislation?
Uniform Civil Procedures Regulations.
Yes. Close. You had it till the last word. Uniform Civil Procedure Rules. Rules. Okay. So the UCPR, that's it. Thank you. And refer to rules 334 through to 345 because they deal specifically with case appraisal. So if you have a question in your take-home paper that calls upon you to consider something to do with case appraisal, I'd expect that you'd refer to certainly the Civil Proceedings Act Queensland, and you'd also refer to the UCPR, rules 334 to 345. Going back to the Act, think about the issue of confidentiality and evidence in relation to this ADR process, and have a look at section 53, which deals with the issue of evidence from ADR processes. Again, the basic rule about confidentiality is said to apply in that section 53 says anything or evidence of anything done. I'll share the screen. Hopefully we can find this fairly quickly. So section 53, sorry, your head will be spinning, says evidence of anything done or said or any admission made at an ADR process about the dispute is admissible at the trial of the dispute or in any other civil proceeding before the court or elsewhere only if all parties to the dispute agree. So that's a little different to the sort of wording that we have in mediation, isn't it? Where there's not necessarily that further statement of it being admissible if everybody agrees. So I guess the question is, for the purpose of the take-home paper, firstly, can you understand the differences and similarities between expert appraisal, expert determination, or neutral evaluation? And when would you encourage these procedures to be undertaken? How would you do that? And what are the factors that might lead to a court doing so? Now, again, there's the general philosophy with ADR that it provides an opportunity for informal, speedy, and effective means of resolving a dispute. So, given that that's a hallmark of ADR generally, you might like to consider, is there some legislative basis for making a statement, an argument, that it would be appropriate to refer the matter because the court is required to assist the parties to come to a speedy and effective means of resolution of the dispute. So the parties can determine the procedures, they can usually choose the expert, they can determine the extent to which they choose to be bound, usually, and even if the matter is not resolved, it might assist the parties because it might more clearly identify the issues for determination by the court. So rather than going to the court and saying, we need a trial for 3 weeks, the parties might be able to say, as a result of an unsuccessful expert determination or appraisal, that now they only need a trial for 3 days. So do you understand how there might be that benefit even if it's not completely successful? Any questions then on those things?
Yeah, John.
Yes, Jack.
So from what I've understood of these 3, again, these seem like they'd have sort of cut their teeth in the construction industry. Where else would they sort of be used? When would it be best to suggest them, if you were to suggest them at all, considering like if it needs a sort of licensed expert, like would perhaps a if it was a medico-legal case, would you perhaps consider it?
Absolutely. Yes, I think it's fair to say that whilst the genesis in a lot of these things may have been in the construction industry, what we're talking about tonight is of much broader operation in practice. And you've actually raised a very good point, and one that you might want to consider for the purpose of the take-home paper, and that is in conjunction with making recommendation for urging the court to make the referral, who would you choose as the expert? What would you be looking for? And if you've got some time to source some experts, look at some websites, do some investigation, that might be very useful as well. And Nadine said that case appraisal can be used in family or family provision as well. Yes, I think so. So it's pretty broad to answer your question, Jack. So good question. Any other questions, comments? All right, we might move on to number 13 of 14, which is the second from the bottom, the closest to arbitration, which is referencing out. So this is undertaken by the court as part of litigation. The parties may agree or challenge some of the findings. The court will appoint a referee. The referee provides a report directly to the court, and the court may adopt it, it may vary it, or it may reject the referee's report in part or in whole. So again, have a look at the Civil Proceedings Act and have a look at the UCPR. So some key questions as you're undertaking the reading. Why would a court choose to reference out? Is the court bound by the decision of the referee? And again, what's the legislative basis for appointing a referee? In practice, what it means is this, that at any stage of court proceedings, except in matters to be tried by a jury, the court may make orders for referencing to a referee, and that is appointed by a court. And what does the referee do? Well, it makes inquiry and then reports in relation to the whole of the proceedings or any part of the proceedings that might be in question. So it's not binding on the parties per se. The report and any conclusions contained in the report are not don't have any legal force until adopted by the court. So again, have a look at the UCPR and the relevant rules there, 501 through to 506. And then of course you've got adjudication, which is adjudication generally, which is undertaken by industry experts, usually to do with the building construction industry. QCAT, for example, has a bank of adjudicators that do a lot of work in relation to the BSIPA Act, the Building and Construction Industry Payments Act 2004. So if you're looking for information about adjudication, which is not one of the 14 listed, by the way, question is, what type of disputes would see the appointment of an adjudicator? What's the legislative basis for appointment? And what power does the adjudicator have? Another instance where you might see adjudicators is to do with body corporate disputes. So have a look at perhaps QCAT and also the Queensland Building Construction Commission, the QBCC. Other areas, and I won't deal with this much this week, we might touch on it in week 12. There won't be a question in the exam on this, but it's to do with the criminal justice system. If you're looking at past exams, you would have seen regularly questions arise in relation to criminal justice. That won't be on the exam this time. I'm not supposed to give you exam hints till week 10, so I've jumped the gun a bit there. All right. Let's move on to the statutory dispute resolution schemes. Court-based ADR, in other words. We've already started to touch on it, but as we've seen, courts and tribunals, both at a federal and state level, now embrace a range of ADR practices And some are compulsory, some are voluntary. So many of them operate within the court and tribunal system, and others are adjunct to them, such as the dispute resolution centres. Now, because many matters are resolved before a matter goes to court, or at least is finalised by a court or a tribunal, it makes sense, doesn't it, to at least advise clients of what they might face if they initiate proceedings. And why not save some trouble, expense, and initiate the ADR process at an early stage if you know what's coming. But to give that advice, you really have to either have the experience or the knowledge to know what's coming. So let's start by looking at the Civil Dispute Resolution Act 2011, which is Commonwealth. I'll share the screen. So far this evening, we've been talking about state-based, Queensland-based civil dispute proceedings. So the Civil Dispute Resolution Act 2011 is a Commonwealth piece of legislation. And you need to consider these pieces of legislation in conjunction with the bills that go with them. So keep that in mind as well. Now, if you want an article or some assistance in this, then it's a lengthy document, goes for 196 pages, but NADRAC produced a report to the Attorney General called The Resolve to Resolve, Embracing ADR to Improve Access to Justice in the Federal Jurisdiction. And have a look at paragraphs 3 and 4 and 5 of the executive summary in that regard, because the material, I won't try and find it now, but the significant barrier to using ADR in the past has been a lack of knowledge and desire to embrace it by people involved in disputes, but also professionals. People just didn't understand it, didn't know how to use it, were suspicious or confused or had unrealistic expectations. So at paragraphs 4 and 5, or pages 4 and 5 of the executive summary, then you'll see the reasons behind this process and why it's important. Do have a look at the recommendations of the executive summary and the requirement to undertake genuine steps. Also in this document at 195, so the second last page, you'll see an attachment D, which is the model clause. And that might be a useful precedent if you ever need to build in an ADR clause into a contract or some other document. Also at a federal level, apart from the Civil Dispute Resolution Act, you need to consider the federal court rules. And Rule 8.02 requires an applicant to provide a genuine steps statement. That is where the Civil Disputes Resolution Act 2011 does apply. So there's the Act, and you'll see Part 2, which is the obligation to take genuine steps to resolve disputes before proceedings are initiated. So if you're advising a client in relation to a civil matter involving federal jurisdiction, then of course you're not going to initiate proceedings, are you, until you've satisfied yourself that you've taken all genuine steps to settle the matter, and that needs to be supplemented by a statement, either by the applicant or the respondent, or more typically both. Have a look at Section 9, which imposes duties upon lawyers. A lawyer acting for a person who's required to file a genuine steps statement must advise the person of the requirement and assist the person to comply with that requirement. So very important. So if we just go back to, firstly, section 3, I'm sorry, I'm going the wrong way. Section 3, the object of the Act. People must ensure that they take genuine steps before they initiate proceedings. Section 4 provides what we mean by genuine steps to resolve a dispute. Section 5 is definition. Section 6 is the genuine steps statement to be filed by an applicant. So what this means is that if someone is going to initiate court proceedings, which is federally based, and it relates to civil matters, then they need to actually set out what steps have been taken. And Section 7 provides that the statement must be filed by respondents. Section 8 is the machinery provision to say that they must comply with additional requirements specified in the rules of the court. So this is where, whenever you're looking at legislation, you also need to consider the rules. Section 9 is the statement or the obligation imposed on lawyers. Section 11 is the fact that courts may have regard to these requirements when exercising powers and functions. Section 12 deals with costs. Now, have a look at this section carefully and think about the obligation that might be imposed on a lawyer, because it says that the court may consider whether a person's lawyer failed to comply with the requirements to take genuine steps and may order costs against the lawyer, who is then prohibited from recovering those costs from the client. How embarrassing if you got shot down in the federal court and, to add insult to injury, you're then ordered personally to pay those costs. When you're considering this piece of legislation, do so in conjunction with the bill. So here we have a link through Parliament of Australia to the Civil Dispute Resolution Bill 2010. And this bill was presented on 2 occasions. And you should consider the explanatory memorandum, which is why this bill has come into effect, and provide some information about what it means. So essentially, it provides that individuals must take this step. It doesn't require parties to take any particular specific step. And the memorandum says that it's a matter for the lawyers and the parties to determine what they believe are the appropriate steps in the circumstances. In other words, the bill is deliberately flexible in allowing the parties to tailor the genuine steps to take into account the circumstances of the dispute. That makes it really difficult. So when you think about this, the Civil Dispute Resolution Act, read in conjunction with the bill, read in conjunction with the explanatory memorandum, says you've got to take genuine steps. If you don't, you run the risk of the matter not being considered by the court and the court ordering the lawyers individually, personally pay costs. But we're not going to tell you what those steps are. That's a matter for you to work out. So it's asking the lawyers to be very cautious about what they do. So you'll understand that as ADR practitioners, you may be called upon to give advice to a lawyer who wants to initiate proceedings in the federal court, but is aware of the obligation to undertake reasonable steps. And they may say to you, here's the factual circumstances. What do you think would be the appropriate ADR steps to undertake in these circumstances for this particular dispute? Because the Act doesn't help us. It doesn't say whether we should go to mediation or whether we should have case appraisal. So do you see why ADR practitioners need to understand the different options and then make a call as to what's most appropriate in these circumstances? Any questions? All good? All right. So I guess you need to then think about what are these genuine steps. A good place to look, NADRAC, as always. NADRAC provided the report, the Resolve to Resolve that I mentioned earlier. And in that commentary, it talks about genuine steps, and it talks about some of the history as to what led to the terminology genuine steps instead of alternate terms they might have used, such as litigating in good faith or litigating after you've made a genuine effort. So they chose genuine steps deliberately. So you need to consider some of these terms. Have a look at page 31 of the NADRAC report if you want some further information about the subjective analysis of what we mean by taking genuine steps. I've mentioned that it's contrasted to some degree at least to good faith. You'll see that term used often, and good faith is essentially uncertain, but you'll see it regularly in documentation and dispute resolution clauses. So when you're undertaking your research in relation to genuine steps, also think about good faith, and to some degree, try to build up that which compares and contrasts the two concepts, and gives and try to develop some legislative basis for that as well. So there are some High Court decisions in relation to good faith and what it means in a court context. A very interesting case is the Legal Services Commission, or Commissioner rather, against Mullins. This is 2006 LPT 12, and it talked about good faith implications in the context of participating in ADR processes. So in this case, there was an issue that arose in relation to a settlement conference, a mediation, and some information came to light. The other party wasn't aware of it. And it really talked about the lawyer's obligations to make this information known. Jack's raised a really good point. I like this one, Jack. Do you want to just let us know what you've come up with?
Yeah. So could you make the distinction that good faith is more about intent or words, sort of those nebulous concepts, and reasonable steps is actually taking an action? So like, it's not really a reasonable step. Oh, I'd like to do ADR, but you're not taking the reasonable steps to engaging with an ADR practitioner.
I think that that's a very good start. So that's a good way of looking at it. I hadn't considered it from that perspective, but I like your thinking. So thank you. All right, so you will need to have a look at some cases as well as the legislation that I've referred to this evening already. A couple of cases you might consider in the context of good faith would be Elizabeth Bay developments against Boral Building Services. It's a 1995 decision from New South Wales. And another one might be United Group Rail Services against Rail Corporation. Again, it's a New South Wales decision from 2009. I do think that they're referred to in your text, but I'd start with those. Now, there is some legislative basis for good faith obligations to be contained in legislation. So, for example, have a look at the Administrative Appeals Tribunal Act 1975, which is Commonwealth, and have a look at section 34, capital A, subsections 3 and 5. So the AAT Act does not include a definition of good faith, but the AAT advises that good faith could be defined as to include genuine effort to uphold the basic principles of ADR. So do some research in relation to those concepts and have some ideas. Now, when we go back to the Civil Dispute Resolution Act, Commonwealth, you'll recall section 4, which provides for the genuine steps to be undertaken to resolve the dispute, and that provides you with some idea of concrete information about it. I mentioned the regulations as well, must always consider, and I'll just share the screen now. The regulations that I'm referring to in that regard are the Civil Dispute Resolution Regulations 2011, and you'll see that that's through the Federal Register of Legislation. Now, you'll also see a note to the explanatory statement. See where my cursor is at the top? So we've got the text in the ribbons across the top, text, explanatory statement, download, enabled by, etc. So very useful is the explanatory statement. It's only short, but it provides you with some indication as to why these things exist. And importantly, why some things that are disputes in a Commonwealth jurisdiction, which are civil in nature, are not subject to these requirements. And the two that are referred to there are in relation to bankruptcy and statutory demands. So there we are, bankruptcy, and further down the page, proceedings under section 459A of the Corporations Act, which are what we call failure by a company to comply with a statutory demand. So they're excluded. They're kind of similar because they deal with people, or companies rather, not paying money, or individuals not paying money. And there's some reason as to why they're not included as part of the regime. So one little trick question, the reason I'm raising this is this. One little trick question for an examination type context might be something along these lines, that you're involved in advising a client to undertake some civil proceedings at a Commonwealth level, in a Commonwealth court. There's a great deal of urgency. Do you need to comply with the requirements to undertake reasonable steps? You're worried about your personal obligation and costs orders against you. The client says it relates to a matter that involves bankruptcy or statutory demands. Then you can see from this that those particular types of procedures are not subject to those general requirements in relation to having to take genuine steps. I know that's a lot of wording, but do you get the picture? Do you get the idea? Statutory demands are really aggressive, for want of a better term, approach that might be used by a party that claims to be owed money by a company. And it's essentially like a precursor to winding up, which necessitates the company upon receipt to apply to the Supreme Court typically to have that statutory demand overturned. So it's almost like an injunction. All right, I know that's a lot of detailed information. We doing okay? All right. Any questions? I'll continue. Just on the common law sphere, have a look at the Federal Court of Australia Act 1976. And in particular, do look at the sections that relate to case management and in civil proceedings. Again, I'll share the screen and take you to the Federal Court of Australia Act 1976. The sections that I want you to look at are sections, sorry, where is it? 37N and M. So the Commonwealth legislation drives me crazy. It's so hard to find. Here it is. Part VB, Case Management in Civil Proceedings, 37M, 37N, 37P. That's really all you need to worry about from this Act. But it's important because it talks about the overarching purpose of civil practice and procedure provisions. That parties must act consistently with the overarching purpose and the power of the court to give directions about practice and procedure in civil proceedings. They're pretty powerful sections. They're not hard to understand necessarily, but when we talk about the obligation of courts and others to resolve matters quickly, inexpensively and efficiently as possible, a question that I posed earlier, you might recall tonight, there's your authority for it in the context of federal court jurisdiction. And that applies generally. So the Family Law Act has similar provisions. Have a look at sections, say 11A, which deals with the role of family consultants, and 60I certificates that many of you are aware of, because I know that because of all the mediations that were involved in family law disputes for your first assessment. Otherwise, do have a look at the Administrative Appeals Tribunal Act 1975 and refer to sections 3, 34A and 34H. I know there's a lot of material. If you're really going to go further with this, in terms of your research at a Commonwealth level, have a look at the Federal Circuit Court Practice Direction number 1 of 2019. I'll share the screen. I will try to share the screen. And you'll see there from the Federal Circuit Court reference to judicial mediations in family law matters. And in big bold print, it is an expectation that practitioners and parties will exhaust all mediation alternatives prior to judicial mediation. So that's another one that you might consider. And there's reference there to what matters are suitable for judicial mediation, and that's something you might consider. All right, just going back to Queensland now. We mentioned earlier the civil disputes resolution. No, I've lost Queensland. I'll stop sharing the screen. So I mentioned earlier the Civil Proceedings Act, the UCPR, and if I haven't already mentioned it, go to the UCPR, look at rules 319 through to 343. I know there's a lot of material that we're covering tonight, and I think we're just about at that stage where I can call it a night, because it's a lot of information and I'm afraid a lot of research. But as you're researching it, please do so actively, because your task is not just to recite relevant sections. You have to apply the sections in a meaningful way, and you may have a question that calls upon you to consider what is the best way of structuring an ADR process that complies with legislative requirements, which means that you have to understand what are the ADR options that are available and what are the legislative and other requirements to which you have to comply. That's kind of the takeaway from tonight. All good? Any questions? Sorry to bombard you, but you've been very patient. Thank you. On a different note, I've been watching a lot of videos and lots of mediation sessions. Not too many conciliations. Almost all were mediation sessions for the first assessment, and I hope to have the results released certainly by the end of this week. So I'd like to have your results back to you quickly. I'd like to have the feedback to you quickly so you can get about preparing for this. Can I just make a general comment that for this type of assessment, I often see a situation where those people that have, over the past years, performed very well and might have a really good GPA, some just don't go well at the ADR assessment, and vice versa. Some students who just seem to struggle really shine through in the ADR sessions because it's a different type of assessment. So please, when you look for your results, don't have any expectation that I'm a credit student, therefore I will get a credit in this assessment. It really fluctuates and there's some big discrepancies because I mark to a wide range. I hope you understand that. It's not meant to scare, but I want to get the marks and the feedback to you quickly. Okay, any questions about what we've discussed tonight or what we're facing? All good? All right. Thank you for your patience. I'll end the session now. We look forward to seeing you next week, and I'll get that feedback out to you for the first assessment very soon. All the best then. Bye.